So
Okay. Thank you, Arcady, for leading our discussion group this morning. And now, Carl, if you want to put the slides up. Carl?
Yeah, I'm getting a message. Steve, I've got a message that says the host disabled participant screen sharing. Okay.
Here we go.
Oh, this is Steve. Did you speak to me? It's Steve Jacosi.
No, Steve Fisher.
Oh, okay. All right. Thank you.
All right, I don't know. Let's see what I have now. Let's see. No, I can't get back to full screen.
The screen is up. You just have to make it full screen.
Oh, that's what you're seeing? Okay, I'm still seeing pictures of people.
No, I'm seeing the flag.
Okay.
I have the flag on.
Now you got it.
Okay. But I have a flag on the other screen on my computer, but not on my viewing screen. But let's see who's live. Stu Madison. Do you see the slides?
Yes, I do. Full screen slide of the flag. Yep.
Me too.
Like normal.
Larry, you too?
Yep.
Okay, good. We'll get started. I'm looking at it on a double screen, so. Okay. I guess we got 57 people here today. Thank you for coming. And we'll start off with the pledge and then our moment of recollection for seeing us through this pandemic. Okay. The pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. We'll take a few moments for reflection. Okay, Carl. Sure you've heard in the news and gotten a message that our member, Dr. Arthur Mostel, passed away. On the screen, he was born in Manhattan. He was 85 years old. He succumbed to complications due to COVID. He attended Stuyvesant High School, Hunter College, and graduated from Albert Einstein College of Medicine. After several decades of private practice, he practiced obstetrics at Metropolitan Hospital in New York City until his retirement. He was an active member of the Shavuot Haitz Chaim. Did I say that right? Chaim. Oh, close. L'chaim, yeah. And the Union Lodge number 5, the Ancient Free and Accepted Masons, previously director at large, a songster for 10 years, and a member of SMAS for 17 years. I think his practice, I think he started at Metropolitan Hospital, but then he and Dr. Robert Madison, who also passed away recently, had their own obstetrics gynecology practice here in Stamford on Strawberry Hill. So he was active in Stamford Hospital and St. Joseph's Hospital, where he practiced the most recent practice. So rest in peace, Dr. Mostel, and we'll remember you as a fine member of our organization. Anyone have anything to say that knew Dr. Mostel more intimately? Would like to say a few remarks?
Didn't know him. I might mention that he had recently gotten engaged and was planning a wedding. So this is a terrible shame. And I think his fiancée was also tested positive, but I don't know her condition.
Joe,
Yeah,
She's okay. His fiance is fine.
Joe,
Ray, yeah.
I've known Arthur for close to 50 years. He delivered both my children. I'm also a member of Chavarot Chaim, and he will be sorely missed. A lovely man. And you're right, last fall there was a combination 85th birthday and engagement party. And we had a Shiva on Zoom this past weekend. And in fact, Janet, his fiance, did survive the COVID. I don't know that she'll survive Arthur's passing. He is rather broken up, as you might expect. But all the kids were here for the Shiva, including his son from Israel, and he will be missed.
Thank you, Ray. Okay. Next slide, please. Okay. John is moving today, so he's been very busy this last week in packing and getting his things together, and so he's closing, moving, doing a whole bunch of things today, and so he'll be busy for next few days. He sends his regards to everybody, and seems to be doing real good. So that's the news on John. Obviously, we will be meeting on Zoom, and we're doing good. We're up at 63 today. We've had close to 70, and I mean, I don't know if it's a question of people not being computer savvy or don't like the format that with the Zoom, but from what I've heard and the feedback that I've gotten from everybody that's been attending the meetings, they're very happy to be here, even though we're not physically close, we're virtually close. So we'll continue the way we have been. Now, one of the things that we're planning is a board meeting on June 4th. And that'll go on after we have lunch after our regular meeting, and the board members will come on Zoom. Either Carl or Steve, I guess either to you will be the meeting set up, and we'll get invitations to that meeting. Meanwhile, any member that has anything that they think they would like the board to review and bring up, some of the thoughts are what we're going to do with the refunds and deposits. And I'm not looking for, at this point, your opinions on it so much as any subjects that you want to be brought up. A couple of things just so, we're going to look at is what do we do during the summer? If this still goes on and we can't physically be together at our the weekly lunches, what do we want to do? What should we do? Another thing is our relationship with the First Presbyterian Church. How do we continue that? So there's a couple of issues, but like I say, feel free to send me an email with any thoughts that you might have that you might want us to bring up at the board meeting. Okay, next. Okay, today, thanks to Phil Schechter again, he's got Tara Thompson is a partner at a law firm, and I'll read that again, when I introduce. Or Phil, are you there? Raise your hand if you. Phil, do you want to introduce Tara?
But we could do that later when she's.
I'm sorry?
We could do it when she's going to speak.
Yeah, I'm saying, would you want to introduce her?
You can do it.
Okay, thank you. All right, we'll get that slide back, Carl, when we are ready to introduce her. And then our future programs, we've got retired recently retired state police captain Mark Sticka, who's a Darien resident, and is a friend of mine. He's going to give us a history and future of the Connecticut State Police. And as I indicated, there's more to the state police than the guys patrolling the highway. They are the police that are at the airport, up at Bradley, and the various other functions that they perform. So we'll get a rundown on that. I think that would be very interesting. On June 4th, Lori has agreed to hold another presentation discussion group live at 11 o'clock. I think she gave us some great insight, and although it's a couple of weeks away, I mean, have some of your questions, a lot of the questions that you were talking about today, investing in gold, I think she touched on last time, and we'll get her opinions on it, and see where we'll go from there. And then on June 11th, we had scheduled for the 4th, but Lori could only do the 4th. We got State Senator Carlo Leone is going to give us a state of the state and hopefully bring us up to speed maybe on what we can expect from a state standpoint on this whole issue. So that I think would be, Carlo's a good speaker, and we've had them before, so looking forward to that. And then we have a couple of more meetings in June that if anybody has any suggestions, I know one of our speakers that we were going to have, Shauna, on discarding belongings and thinning out our homes, indicated that because some of these places where you can donate are shut down, she didn't think now would be good, so we've got her scheduled. She's going to open up our season in September, so hopefully by then things will open up and she can give some of the advice that she wanted to give at that point. So, moving on. Ira, floor is yours.
Last week we had attendance of 65, including 3 guests, Debbie Softmeyer, Mo Glucksman, and Alan Coulter. Everybody, I assume, received the minutes. Are there any corrections or additions that anybody would like to make? Joe, it's up to you.
Okay, I do not see any checks made, so you're good to go, Ira. Thank you for
Very
what
good.
you're doing. Okay, Larry, you're up. Save the dates.
Following save the dates. Postponed until further notice. Again, the SMAS day of service. Hopefully can get rescheduled in the fall. What's been canceled, the spring golf outing. Postponed until fall, the tennis tournament. Can you move the slide up? I like Snoopy's form. Wednesday, June 24th, the spring luncheon. I have it down as status uncertain, to be advised. I did talk to Rock Rimmon yesterday, to the events chairperson. Rock Rimmon Dining Room is currently closed. They have not formulated a policy as yet as to holding events. But I suggested that it is unlikely that big gatherings will be allowed at the date that we are scheduled to be there. And I'm not certain that because of the ages of our membership that we would likely have a lot of people wanting to participate in big group outings, that we would probably not go forward with this. And I requested that they return our deposit. The events coordinator has to talk to the general manager. I have not heard back, but I expect to today or tomorrow or over the weekend. So I will follow up and advise everybody.
Larry?
I expect that it will not go forward.
Please wait to be called when the speaker is speaking, and we'll call on you. Raise your hand. Okay, Stu.
Yeah, Larry, I think in the paper this morning, it's not, I think it says June 20th, the mayor's just going to open up to 50 people at that time, then getting together. So it ain't going to happen on the 24th, for sure.
Right. What was the date? I'm sorry.
June 20th, the paper says June. Right now it's like 5 people can get together.
Right.
On June 20th, it's going to be raised to 50 people.
Okay.
Max.
Right. Okay. Thank you for that input. I appreciate it. Next slide, please.
All right, I'm sorry, Larry. So effectively, we are canceling the spring luncheon.
That is the plan. It is not formally done yet, but it will.
Well, I think at this point, it's a month away, and even if we were to do it, it'd be very difficult getting signups, and so.
I agree.
Yes, I think at this point, let's officially cancel the spring luncheon, and then see where we go from there. I mean,
Okay.
if anybody disagrees, signal by clicking the no. But it does make sense not to prolong the decision.
Right, I agree.
Okay, so the spring luncheon, unfortunately, is canceled.
Okay. The summer fishing trip, I think Mort is on. So Mort, do you want to talk about it? Unmute yourself, Mort. Steve, can you unmute Mort?
Can you hear me?
Yes.
Oh, okay, great. So what it says on the screen is true. The problem, Bobby, pick that up. It's over there. Hi, can you hear me still?
Yes.
Okay, so it says SMAS fishermen. A lot of fish are waiting for us. That's a direct quote from the trip will be July 8th. I quoted you a different date, but that is the current date now, July 8th, where it'll be warm and the fish love to be caught during warm weather. The price is $60 a person, and bring a bag lunch to eat beforehand. There's a place to sit near the parking lot. So please call me at my home. There's my number, or email me and let me know of your interest. And thanks for my allowing me to speak at this meeting, because I couldn't come to the last meeting. And it's a pleasure. The meeting is so well run, Joe. It's terrific. Very, very interesting. I'm going to sell all my gold soon, I think.
Thank you,
Mort, we look forward to having you update in the following week as to the participation. So
Okay,
please
I'll
be
keep
on the meeting.
contact. Please encourage members that you meet to come out and vote, come out and fish, and maybe tough getting people, but it's like going to be 10, 12 people sitting on a boat, and we've been on that boat before. There's plenty of room. You don't have to sit next to people. You can spread out. I hope it goes through. It should be very enjoyable, and I'm looking forward to it.
Well, just remember, you're all in the same boat. So.
So that's the kind of things that pulls programs off the air.
I like the fish that this lady is exhibiting. That's a nice catch.
Look at that Bob Butke boy.
Butke looks good with his flatfish there.
Yeah, but he makes every fish look much smaller than they actually are. The reflection that you see is larger in person than in your mirror.
Okay.
But that's the ship, that's the boat, and you can see the person sitting there, excuse me, and how much room there actually is.
Mm-hmm.
This is another exaggeration over here of the nice lady that caught that big bass. I've caught the biggest fish, actually, and we don't want to show that picture, but.
Oh, that bass is bigger than anybody.
Don't believe that. First of all, women are not even allowed on the boat, usually. But in this day and age, you can't say that. But that's the problem. They catch the fish and win the prize and win any money that's bet. And so.
Let's give Sandy Barocas her due, Morty.
Is what?
Give Sandy Barocas her due for catching that fish.
Oh. Well, she's allowed to do that. He's not, her husband's not allowed to do it.
Okay, moving on to the picnic.
Stu, you want to speak to it, please?
Thank you. Good morning, guys. As you can see, currently the picnic is scheduled for September 15th. It's a Thursday. It would normally take the place of a meeting. It was like every other year. It's going to be. Might be at Cove Island Park. The mayor is confirmed. The caterer is confirmed. Parking that day, no enforcement. But the however is, given the I guess the age group that we're in, the rules about being 65 and older, social distancing, the masks, and the meeting size. I want to ask the question: if we were allowed to meet legally, in other words, there's no restriction on the size of the group and that kind of thing. I'd like to ask, by show of hands, who is likely to attend? So,
Please press the green button.
For yes. Yeah,
For yes.
will you attend? Yes or no? Raise your hand now. I asked Steve to do the counting. Okay, Steve, do we have a number?
24 and 9 no's.
24 yes and 9 no's. Interesting. Okay, thank you very much.
10 no's now.
10 no's, okay.
Okay, a couple of guys raised their hands instead of the yeses, so I don't know if they're saying they're going to come. Carl, are you going to come or?
I have a question or maybe a suggestion. I'm sure the caterer is going to be thinking of this, but I assume we'll be abandoning the buffet style and have some other means of serving. That might quiet somebody's reservations about attending.
Yeah, we'll have a lot of things to figure out. I mean, we don't know the rules yet, really. But I just wanted to get a rough idea, and it seems like, roughly, people might attend. Hang on one second. Got noise outside. All right. Thank you, Wes, for the voting. Next slide, Carl.
Yeah, one thought on that too is, maybe throw a little light folding chair, and that's me. Hold on a second. It's a V call. So bring a folding chair. You can sit out, if you want to distance yourself, sit outside a little, out of the pavilion, especially if it's a nice day. So it looks like it's enough for 21 saying yes. That means there's 40 something people.
All right, we'll just take it under advisement.
50.
Yeah.
Okay, continue along. All right, so the committee did meet this past week, and I mean, roughly we're thinking maybe, we might not have gifts, if we might not have a raffle or a silent auction, primarily because we don't think restaurants are going to be so anxious to give out anything, and this will be a bad time to start asking them. So we're thinking about that. We also would delay a final decision until July, because we still have, since all the logistics are actually in place, it's easy just to cancel at any time. 2 months ahead would give us time to get a fairly good representation as to who would attend, and so we'll wait till July to let you know what we're going to do finally. One alternative came up, if we can't have the picnic, we can't meet, to still use that date and just make a program out of it. It'll be like now, it'll be a meeting, but since the mayor is committed, I'm sure he would still be willing to talk to us online. Maybe we could find an additional speaker to talk us about some interesting topic. And maybe we can come up with some fun things to do online. These are just general ideas. But if anyone has any idea at all, send me an email. Glad to consider anything. Are there any questions at all?
Well, it is a meeting day, so if the picnic doesn't go off, we would still have our regular meeting, and we'd have the mayor, speak at a meeting. So that doesn't. So your suggestion there pretty much is, if we want to have a formal meeting or a fun meeting, and then have the mayor.
Yes.
That either way, should be no problem.
Getting the mayor.
And hopefully by then, John will be coming back and running the meetings. Let him worry.
Aren't
But
all meetings fun meetings?
I enjoy doing it, so no matter what. But yeah, no, I think your suggestions about the no gifts, because, you know, how many do we order? It's a couple of $3 outlay. So if we don't have the gifts and we have no raffle or silent auction or no silent auction, not buying the gifts will defray the cost that some of the costs that we would make up with the auction. So it should be a wash there. And
Well, it's just a thought right now.
yeah, and I think it's a good idea. Having been involved getting those gifts.
Yep. All right. Thank you very much.
Thank
Okay,
you.
next slide, please. Monday, October 5th, the fall golf outing is scheduled. Obviously, hopefully things will straighten out. I will let Brian or Howie speak to it in a moment. I would just like to point out, based on my personal experience, that the golf course is the most popular place in town currently, and it is quite simple as at this point everybody's obeying the rules, wearing their masks at the check-in place, and keeping social distance, which is very easy to do on the golf course. And you know, if you're not aware, there's no rakes. The holes are raised, so you don't have to dig down deep to pick out your ball if you sink a putt. And you know, they're going ahead full speed. So again, it's as of this point in time, single person carts. A lot of people are walking, but and the carts are all sanitized before play and between play. Brian, you have anything to add, or Howie?
I think I would add only that it might depend a lot on if we'll be able to gather afterwards too. Not only the golf, but I think an important part of this will be if we'll be able to, you know, eat afterwards.
The upstairs lunch place, I believe, is open, and it, you know, could be, it's spacious, so it could be feasible. So we'll have to check it out as it gets closer.
Exactly.
All right, Brian, a question, Brian. Depending upon the situation, are we limited to a minimum number? I mean, let's say we get 16 four foursomes instead of the 8. I don't think it's going to be an issue.
I don't think that's a problem, but I'd rather have Howie speak to that.
I don't know if that'll be an issue. We were limited to 30, if I recall. I have to check my notes. But the question is, who's going to feel comfortable eating upstairs where we can't say for 16 people that will reserve the whole room? And you got, I mean, I played yesterday, and there are a lot of young guys out there not giving a shit about social distance. And I mean, it's party time. And our age is not party time. So the question is, are we going to feel comfortable?
Well, I think let's look.
Answer that for themselves.
Let's look at it from two standpoints. Let's look at it from golf as a get together to play golf, and having a luncheon as a second phase of it. So
I agree with you.
Yeah, so let's wait until, I mean, you know, until September. I'm just thinking if only 16 come out to play golf, is that going to be a problematic with the course, or are they going to still allow us to go out as a
I
foursomes?
think you would allow us because we're going out early enough.
Okay, great.
And it's also on a Monday, and by that time, a lot of people will be going back to work.
and it's an odd day, so we could use the carts.
Okay. One thing, Brian, unrelated to the golf, for the board meeting, will you have a update on the finances?
Yeah, sure, I can do that.
Okay, great. Thank you.
Had a projection.
Next slide, please. Tennis tournament scheduled for Monday, October 12th. Larry, since you're on board, have anything to say? Larry Berger? Joe, are you on? Okay, neither one are responding, so I'll just say it's scheduled for Monday.
I'm on. I'm on also.
Okay,
Can you hear me?
yes,
We're definitely going to have a tennis tournament. We don't have lunch afterwards, so that doesn't seem to be a problem. I understand some of the indoor clubs are putting certain restrictions on that they're only playing singles and you have to use your own tennis balls. This shouldn't come into play at Scalzi. We should be having it at 9 o'clock. It lasts till 11 o'clock. And hopefully we can get 16, 20 players to join us. Again, we're definitely going to have it. We'll start collecting, as it says on here, September 10th. And hopefully we'll have another successful tennis tournament. A little bit later this year, but hopefully successful.
thank you, Larry. Next, I think that does it for me. Carl, I turn it over to you.
Okay. Well, first of all, do we have any guests joining our meeting today? Okay. If not, we have two of our guests from last week, Mo Glucksman and Alan Coulter, have submitted their applications and have accepted as new members. In addition, Joe Mattel and I were able to recruit Carl Shapiro, and Carl Rosen attended a Zoom meeting a few weeks ago, and his name was included here. He actually joined 2 weeks ago. So we're doing very well. The combination of the recruiting efforts by our members and the incentive of no dues for May and June are working, and our membership is up a couple points this year. So I encourage everybody to keep up the good work and keep encouraging people you know to participate.
Carl?
Yes.
Stu, this is Stu. I think he's on now, a neighbor of mine, his name is Steve Giacosi, who's listening in today.
Okay. Can you spell the last name for me?
Giacose. I'll give you the details later.
Great. Thank you very much. Good work.
Bill.
Hi, good morning, everybody. Hope everyone is in good shape. From last week, we heard about Jack Austin going back into the hospital and coming out. Does anybody have an update that they want to share with us? Any good news?
No good news.
Stu?
Yeah, please.
Stu, you have your hand raised.
Oh, that was for Carl.
Oh.
I didn't unraise.
I have a question I'd like to throw out. Does anybody have any idea where you can get gloves?
Yeah. You can get gloves on Amazon, but it's yet a couple of weeks wait.
Well, like a month.
They are selling. I'm sorry.
Gloves available at the Wave Fish Market. I also saw gloves available at Fairway.
At where?
Fairway.
Fairway.
Phil?
Thank you. Yes.
Our neighbor has plenty. Be glad to give you some.
Boxes of gloves?
Yeah.
I don't know who offered.
Alan, I offered.
Oh, okay. Thank you, Alan, my next door neighbor.
Phil, I have some news. It's Jerry Kranz. Been keeping tabs of the members of the songsters. Warren Hayes is still at Stamford Hospital. He hoped to be home this weekend, but they decided that Van Munching for rehab was a better situation for him. So I don't know exactly when he's going to be getting home after his operation. Just a comment, I didn't have a comment with Arthur Mostel. Obviously, he was a member of the songsters. He sat next to me, and I will miss his bass baritone singing quite a bit, and Arthur really knew his music, and from a technical point of view, and I loved stealing notes from him when I couldn't follow what was going on.
Jim McEwen? Jim, unmute yourself.
I met Arthur 6 years ago, Arthur Mostel, when I joined a group of men taking care of their wives with Alzheimer's. And I don't know if you hold it against them, but Arthur, Henry Van Dam, and Stanley Pelter were all members of that group. They actually talked me into joining this group. And Arthur was really, for the care group, he was extremely helpful. His insights were great.
Thank you, Jim. One thing, Stamford Hospital now is opening up for elective surgeries. My wife, they're talking about having her go in on the 14th or 15th, the week of the 14th, for some reversal work. So things are starting to open up, and that's good because, you know, some of these elective surgeries, if they don't go on, they become major later on. So if anybody's got anything that they want taken care of, speak to their doctors. One thing they're doing is before you go in, within 48 hours of going in, you have to get COVID tested. And so that you know, they're taking the precautions. Last I heard, they were down to only 30 patients at Stamford Hospital with the COVID, and the National Guard and Army Reserve pulled out the other day. In fact, when we went to the doctor's office over at the medical office building, we saw a commotion going on, and that was them, you know, pulling out of the hospital. So little by little, things are getting.
Our speaker has joined our meeting. Sarah has joined our meeting.
Okay, so we were going to finish up with Dick Harper. Dick, are you around today? You see Dick on the list? I don't.
Hello.
I saw him earlier.
Good
Oh, there you
morning.
are.
Yeah. So we're doing Code Girls on the 3rd, and I hope to get the Zoom connection out by tomorrow to all the people who are on the book group list. And this Code Girls has been an interesting book to read about how so many women were extremely important in the Second World War. Pretty secret thing until recently when books started being written about them.
Thank you, Dick.
Okay.
Moving on. All right. Since we're at the time, we'll hold off discussions. And I know Stu had something to show, but we'll hold that for next week. Stu, is that okay?
Yeah, that's fine. Like, yeah.
Okay.
Just some funny stuff. You know.
Oh, you want to go back to the?
I just might mention, Larry, here that quickly, NBC News was on broadcasting from Bedford Street yesterday, and in front of Capriccio's, and it looked like they were doing a pretty good job keeping the tables well spaced out, and some people were wearing masks when they weren't eating. So things are starting to look like they're returning to a bit of normalcy.
Yeah, I was at Capriccio's when they were there last night. My wife and I were there. It worked out very well. It was our first time out in 2 months.
Oh, who was that, Joe?
Al.
Heard it,
yeah.
Oh, okay.
Okay, that concludes our meeting session. Tara Thompson is with us. Tara, are you ready to?
I am.
Oh,
I am. Hello, everybody.
Hi, I'm going to brief introduction and then we'll turn the meeting over to you.
Great.
For your presentation. Today we have Tara Thompson speaking on putting meaning behind the Bill of Rights, civil rights litigation in the United States. Tara is a partner at the law firm of Lovey and Lovey, one of the largest civil rights firms in the United States. She spent the last 13 years bringing civil rights lawsuits all over the United States, focusing her practice on wrongful convictions and police misconduct litigation. She also works with the Exoneration Project, a nonprofit that, in partnership with the University of Chicago Law School, represents those convicted of crimes of which they are innocent. She is a member of the board of the Innocence Network, a national organization of innocence projects. She graduated with honors from the University of Chicago Law School and previously worked as an associate at Mayer Brown. She also served as a law clerk for the Honorable Elaine Bucklow in the United States District Court for the Northern District of Illinois. Without any further ado, Tara, the floor is yours.
Thanks, Joe. Let me just say two things before I start. One is, what's our end time here, just so I make sure that I stay on track timing wise?
Okay, we try to shoot for 11:30 and then wind down and then have 10 to 15 minutes of questions, which I'm sure there will be. And I just want to remind everybody that if you want to speak, raise your hand and wait to be called on afterwards. Okay, go ahead, Tara.
Yeah,
Sure.
by raise your hand, we mean from the participants, not hold your hand up to the screen.
Okay, go ahead, Tara. I'm sorry.
The other thing is, I've got a little PowerPoint here to explain some of what I'm talking about. So can I share my screen here?
Yes, you can.
All right, let me do that.
We got it.
All right, great. Let me just go to presentation mode. All right. So thanks for the introduction, and I'm really grateful for the opportunity to speak to all of you today. I noticed even before I came in and started talking that you were all talking about coronavirus. Some of you have probably seen that there's been some lawsuits filed in various states challenging different governors' reopening orders. Or their shutdown orders, and arguing that, you know, governors don't have the right to force people to remain in their homes. Those lawsuits are one kind of Section 1983 lawsuit, civil rights lawsuit that I'm going to talk about today. You know, those lawsuits, the ones that are filed in federal court, are being filed by people saying that a governor forcing them to stay at home is violating their rights under the United States Constitution. And in a broader sense, you know, that's the kind of civil rights litigation that I'm involved in as well. And what I thought would be interesting to talk about today is how it is that people bring lawsuits for the redress of their rights under the Bill of Rights, and what exactly the Bill of Rights means, and how it's enforced by people in the United States today. So I want to give a little bit of a historical context for where that comes from in the law, where the authority for these lawsuits comes from constitutionally and historically, and then talk a little bit about how these lawsuits work. And then I'm happy to answer whatever questions people have at the end. So first, a little bit of constitutional history for everybody. I'm sure everybody here is familiar with the Declaration of Independence. You know, the Declaration of Independence says, we hold these truths to be self-evident, you know, that all men are created equal, that they're endowed by their creator with certain unalienable rights, that among those rights are life, liberty, and the pursuit of happiness. And that to secure those rights, we have governments. So even in the beginning of our Constitution, the founding fathers were thinking about what are people's unalienable rights? What are the rights they have that come from, you know, if you're a person who believes they come from God, if you're a person that believes they come from our inherent value as humans, whatever, what are those rights? How are they recognized in the Constitution, and how do we enforce them? That's what we're talking about here. We typically think of the Bill of Rights as something that's primarily enforced through criminal process, you know, that this is part of the rights that people have in criminal court. You know, you're probably thinking about people's right to remain silent, people's right to have a lawyer. You know, those are the typical rights in the Bill of Rights we're thinking about. And a lot of those rights are enforced as part of the criminal process. People that are criminal defendants, you know, argue in a trial that certain evidence shouldn't come in because it would violate their right, or they appeal and say that their conviction should be vacated because their rights were violated. And that is a key way that the Bill of Rights is enforced in the United States. Another way it's enforced increasingly is through Section 1983 litigation. And people bring lawsuits under Section 1983 to redress some violation of their right by a government actor. It's what we call a constitutional tort. And I don't know how many lawyers we have in this group. You know, a tort just means essentially something that someone has done to hurt you that you have the right to redress. Constitutional torts are something that somebody has done that hurt you, that was a violation of the Constitution, that you have a right to redress. And this particular statute gives people a mechanism for addressing those wrongs. So the first question, I think, is from a legal and a historical perspective, how did we even end up with a Bill of Rights? I just read you, you know, that portion from the Declaration of Independence that says, you know, we, the founding fathers, recognize that we have these unalienable rights. That's, you know, the Constitution was passed, or at least was passed in the Constitutional Convention in 1787. New Hampshire was the 9th state to ratify it the next year, and because that was 9 of 13 states, the Constitution became law. But importantly, and you could all go pull out a copy of the Constitution after this and look at it, the Constitution really explains, here's our government, here's how the government's going to be set up. You know, we have a judiciary, a legislative branch, an executive branch, as far as the federal government is concerned. But the Constitution really doesn't say anything about what rights are reserved for individual people vis-a-vis the government. It doesn't really say anything about that. I mean, I just read you the part of the Declaration of Independence, which is the only part that mentions anything about it at all. It talks about these unalienable rights, but it doesn't explain exactly what these rights are. Now, around the time that the Constitution was being ratified by the states, there were various people in Virginia that said, you know, one concern we have about the Constitution is that it doesn't say what rights are reserved for the people. And various people in Virginia, James Mason among them, said, we want a more explicit guarantee of what rights the people has, because the Constitution is silent on this. The framers, and in particular, James Madison and other people that sort of were part of his part of thinking, they said, well, we don't really need a Bill of Rights because you should just assume that the only rights the government has is what's in the Constitution. And if it's not in the Constitution, it's not a right of government, it's a right of the people. But other people said, no, we need something more explicit. And in Virginia specifically, in Virginia and the Commonwealth, they were working on a Virginia Bill of Rights. They were basing that on the Magna Carta. They were arguing a lot about this. And because Virginia was such an important part of the United States at that time, that helped lead this push for a greater Bill of Rights in the Constitution. And Thomas Jefferson, here in the quote that I've got on the screen, explained what he envisioned the Bill of Rights to be. He said, You know, that's what the people are entitled to against any government. What no government should refuse or rest on inference. So that's what he said he wanted the Bill of Rights to be. And finally, James Madison and other people got on board, and they introduced the Bill of Rights. It was introduced into Congress in 1789, and it was ratified in 1791. So it's kind of, you know, it is actually amendments. We're going to go through what those amendments are, but it's these addendums to the Constitution to say, you know, we said what government's supposed to do. We said what rights the federal government has, what rights these different branches of government has. Now let's talk about the specific rights of the people. Although there's a lot of amendments to the Constitution, and obviously we get more, especially around the time of the Civil War, when we get amendments that clarify that slavery is unconstitutional, that, you know, eventually give women the right to vote, etc. The Bill of Rights is typically thought of as being the first 10 amendments to the Constitution. And again, you can go through and read these, but in brief terms, you know, we all know about our First Amendment rights. That's our freedom of religion, the amendment that says that the establishment of religion by the federal government should be outlawed, freedom of speech, freedom of the press, freedom to assemble. That's all in the First Amendment. The Second Amendment, which obviously gets talked about a lot, is the right to bear arms. The Third Amendment, we don't talk about too much. That's no quartering of troops in private homes. The Fourth Amendment, which is a big, you know, an important amendment, especially in the criminal law context in the United States, prohibits unreasonable searches and seizures. The Fifth Amendment is a lot about trial rights, the right to a grand jury before charges are brought against you, the right against double jeopardy. You know, if you're acquitted at a trial, they can't try you again. You can't be compelled to be a witness against yourself. Your right to due process, and your right against the taking of your property by the government. The Sixth Amendment, you know, you have a right to a speedy trial, you have a right to a lawyer, also about trial rights. The Seventh Amendment is that you have the right to a jury trial, including in civil matters. The amendment talks about matters over $20 is at issue. The Eighth Amendment is really about punishment, you know, no cruel or unusual punishment. That's where a lot of death penalty litigation gets addressed. No excessive bail or fines. 9 and 10 kind of are duplicative a little bit. I mean, 9 says, you know, just because there's certain rights set out in the Constitution doesn't mean people don't have more rights than that. And 10 also makes very clear that if there's powers that are not delegated to the United States, those powers are reserved to the states or reserved to the people. So it's trying to say, if we didn't explicitly give the federal government that right, you know, it doesn't belong to them. It belongs to the states or the people. So you know, the Bill of Rights is passed. That sets out a lot of rights for people. Does anybody really start litigating these rights or talking about what they mean? No. You know, nothing really happens after 1791 when the Bill of Rights is passed. And that's for a couple of reasons. One is that there's the Supreme Court case in 1833, Barron versus Baltimore, where the Supreme Court says that the Bill of Rights only applies to people's rights, you know, vis-a-vis the federal government, not their rights against state governments. So if, you know, the federal Constitution says you have the freedom to assemble, that's really only about the federal government preventing you from assembling. It's not about the state court government preventing you from assembling. There's this view in this period of American history that, you know, states' rights, something we hear about a lot in another context now, you know, that your freedoms against the state are what the state gives you. So if your state constitution wants to give you certain rights, they can. If they don't want to, they don't have to. So just because the federal Constitution says you have the right to a jury doesn't mean that if you're being tried in state court, you have the right to a jury. That's the view of the law in the 1830s. In addition, I mean, that's sort of how things go through that period of time. Then we get to the Civil War. And as we just talked about, there's additional amendments that are added to the Constitution around the time, you know, right after the Civil War. There's an amendment that's outlining slavery. And then there's the 14th Amendment, which does a lot of things. And over time, really kind of into the 1920s, there's various court cases that make clear that what I just said is no longer true, that the Constitution applies, the rights in the Bill of Rights apply to the states too, not just the federal government. So again, when that, when the Bill of Rights says you have the freedom of religion, that's a right that the state has to respect as well as the federal government, regardless of what your state constitution says. So that starts to be true from kind of 1868 when we get the 14th Amendment, and then cases that interpret it for, you know, about the next 50 years. There's something else really important that happens at the end of the Civil War. There's a Civil Rights Act passed in 1871, which is also called the Ku Klux Klan Act. And this act is passed because of the violations of people's rights that are going on in the South after the Civil War during Reconstruction, particularly against people of color in this country. And this Civil Rights Act says that any person who is acting, under color of a statute, an ordinance, or regulation, who deprives someone of their privileges or immunities secured by the Constitution, is liable to that party in a proceeding for redress. So this is maybe starting to sound a little familiar. Okay, now the Congress has given people the ability to, sue someone to bring a case if their rights are violated by somebody who's acting under color of law. We're going to talk about what under color of law means. So 1871 gives this important statute, Section 1983, which gives people the ability to actually sue if their rights are violated under the Bill of Rights. Like a lot of legislation that's passed during the Reconstruction era, this seems to be very clear about what rights it gives people, but nothing, again, really happens after 1871. They don't really use this at all for almost 100 years because even though it appears to give these rights, that's not what courts are really willing to entertain, and courts do not want to get in the business of doing these lawsuits. And so they really don't for almost 100 years. Part of the reason they don't is because it's interpreted to mean, essentially, when we're talking about under color of law, that it only really applies to challenge specific statutes or ordinances, laws essentially that are unconstitutional. So it appears to say that if you have a law that is unconstitutional, that you can bring a claim under Section 1983 for redress. And that obviously limits what people are going to do with that significantly. Because if you have to wait for, like your state legislature to pass a law that violates your freedom of religion, for instance, or the federal government, you're not going to have that many instances where you're going to really use that statute. In 1961, the Supreme Court issues this decision, Monroe v. Pape, that says, no, if somebody is a state actor, meaning they're a state agent, we'll talk about that, who's acting under color of law and they violate your rights, you can sue under this statute. So this really is the first time where the Supreme Court recognizes we're not just talking about unconstitutional laws, we're talking about the actions of people. This, obviously, it's 1961, the civil rights movement is underway, and people start to use Section 1983 now to challenge state actors that they think are violating their rights, in terms of preventing people their right to vote, preventing people their right to due process, preventing people, other rights that are guaranteed to them under the Bill of Rights. And so we actually start to see a lot of litigation from 1961 onward using Section 1983. And now we're in a world where Section 1983 is used all the time. For all kinds of different suits, for the state closure suits that I talked about, for police misconduct and some of the specific work that I do, suits challenging the unconstitutionality of laws that, prohibit the practice of religion, for all kinds of different violations of people's rights under the Bill of Rights. And we're going to talk a little bit about that. What I want to talk about in terms of Section 1983 as it's thought of in modern times then is to talk about what kind of people can be sued under Section 1983, what kind of conduct is actionable under Section 1983, and what available remedies are under the statute. So let's start with who can be sued, who are defendants. It's interpreted essentially like the statute we just looked at, the language of the statute, that it has to be people who are acting under color of law. And so the obvious thing you're thinking about when you read that is, okay, this is people who are employed by the government. And remember, we talked about, because the 14th Amendment applies to the states, we can be talking about federal government employees or state government employees. It's anybody who uses or misuses their authority because of their official position. So something that frequently comes up in these cases is, you have a police officer, for instance, who, beats somebody. I mean, let's just think about the worst sort of police misconduct that you can think of, where a police officer just hauls off and beats somebody up on the street. You might say, well, how is that person acting under color of law? You know, what they're doing is wrong. What they're doing has nothing to do with their job. You know, they're doing something that's illegal and they're violating the law. So are they really acting under color of law when they do something that's obviously not part of their job, that's just wrong? What the law has made clear over time is that it doesn't matter if somebody's actually violating the law and doing what they're doing. If their position of authority is used to accomplish what they're doing, then they're still acting under color of law and they can be sued under this statute. The kinds of people that end up getting sued most often in 1983 can vary because it depends a little bit on sort of the remedy that you're seeking. We'll talk about that a little more in a minute, but to go back to the example I just used, people are suing in federal court for these shutdown ordinances, and they're arguing that the ordinances by the governors to shut down the government to prevent people from going places, you know, to force people to stay in their homes, that those are unconstitutional. And they're suing for injunctive relief in most of those cases, meaning they're just asking for an order that prohibits the governor from doing that. For injunctive relief, obviously all kinds of government officials get sued for injunctive relief. You know, clerks who won't issue a marriage license, or a governor who's, you know, got a certain order that they're trying to enforce, or local government that's doing something specific. You know, in those cases, the person you're suing is the person who has the power to enforce whatever law you're upset about. When we're talking about suits for conduct, for things that people are doing that are wrong, most often those lawsuits tend to be brought against law enforcement, prisoner civil rights litigation, which we'll talk a little bit about. Obviously, you're suing prison guards and correctional officers in those situations, school officials, people who have government authority who are misusing it. Those are who your defendants end up being. Section 1983 also specifically talks about people, you know, so there's a question about, well, who is a person under Section 1983? Because we usually think about people being individuals. There is law that says that your government is not an individual for the most part. And so if you're saying, you know, my school board passed this rule that said that, you know, I'm not allowed to pray in school, and you want to sue somebody about that, either to get an injunction to prevent that from happening or whatever you want to do with that, you might say, well, hey, a school board, I guess there's specific people that I can sue, but what if there's not really a person? What if that's just sort of a board decision and I don't have a person that I can bring in as a defendant? Can I sue my school board? There was an important Supreme Court decision in the 70s called Monell versus the Department of Social Services that says that a municipality, so a city, a town, a municipal agency like a school district or a school board, or whatever sort of subdivision of local government that we're talking about, that's a person if its official policies are the moving force behind the constitutional violation. So in that sense, if you're talking about policies, a municipality is a person that you can sue under Section 1983, if you can show that their policy was the moving force behind whatever caused the violation. So what kind of conduct is actionable under Section 1983? This is a little more obvious. You know, it's conduct that violates your rights as secured by the United States Constitution. And again, primarily we're talking about the Bill of Rights. We're talking about the 10 amendments we just went through, your freedom of speech, your freedom of religion, your freedoms as it relates to criminal process, unreasonable searches and seizures, all the things we talked about. That's what you can sue for under Section 1983. That conduct has to be the proximate cause of whatever violated your rights. So you have to show that the person you're suing actually caused you to be deprived of your rights. An important issue that comes up in these cases a lot too is, you know, what are we complaining about? What is the mens rea or the intent of the actor that has to be present for somebody to be sued? And the important thing under Section 1983 is to bring a suit, we're not talking about, you know, honest mistakes. We're not talking even really about negligence under the law. We're talking about, for the most part, showing that somebody was malicious in their conduct, or at least that they were deliberately indifferent, meaning they knew that they were violating your rights and they didn't care. You know, that's the standard of intent that you have to show in most of these cases. So if somebody just messes up and makes a mistake, and they didn't mean to make the mistake, you don't have suit typically under Section 1983. You got to show a lot more than that. There also are various people or types of behavior that is immune. Immunity is a really important issue under Section 1983. And the way that this has been interpreted by the courts primarily is to sort of go back and look at the state of the law at the time Section 1983 was enacted. So we're going back to the 1870s, and we're saying in the 1870s, who were people who couldn't be sued under the law, because we're not going to let you sue them under Section 1983. This is not an immunity for an injunction, and we'll talk about that more, but this is, if I'm saying you violated my rights, I have damages, I want to recover money from you, who can you sue? Well, the law has pretty much always said that you can't sue the president for damages. You can't sue a judge, you can't sue prosecutors, you can't sue the legislature. You know, if you don't like the law the legislature passed, you can't sue them for damages. All those people have been immune under, you know, English common law, and that doesn't change under Section 1983. You also cannot sue people for things they say in court. So even if I get up in court and I, you know, again, I'm a police officer and I get up at a trial and I just straight up lie and I say, you know, I saw that person shoot somebody, even though I'm lying, I know I'm lying, I am committing, you know, perjury. You cannot sue me for things I said in court. There's something called testimonial immunity, which means that you don't have any suit there. You can't sue prosecutors, you can't sue judges. All those people are immune. There's also various immunities that are recognized under the law as a matter of practice. So for the most part, you can't sue, you know, social workers. You can't sue like 911 dispatch centers. And the reason why is those are immunities that have been carved out over time by the law to say, we want people that are social workers to try to do their job and not worry about whether they're going to get sued. So we're not going to let you sue them. We need to have 911 dispatch centers, and we don't want the 911 operators to worry they might get sued, because we want those centers to exist. So you can't sue them. There's various immunities like that that are at play too. More importantly, there's something called qualified immunity. And this basically says, and I want to be clear and go back a little bit to what we're talking about when we talk about the Bill of Rights. You know, we're saying that if you as a person believe that your rights under the Bill of Rights have been violated, so again, you believe that you know, your freedom of religion has been violated by a state actor and you want to sue somebody about that. The law says that if the person who, you know, is the reason that your freedom of religion was impinged upon, if they are acting under their discretion, meaning they're just doing their job as a government official, and they really didn't know that what they were doing violated your rights, they're immune from suit. And the law says you really look at, you know, what would a reasonable official know about what they were doing? Would they understand that what they were doing violated your rights? If the answer is no, then you can't sue them. So you're probably saying to yourself, well, that seems like that would cut off a lot of people, because again, we're talking about if somebody's doing their job and doing their best and just really didn't understand that they violated your rights, you can't sue them. The law gives a lot of exceptions for sort of what conduct is going to be actionable under Section 1983. We talked about this a little bit, but a big question that people have under Section 1983 is what remedies are available. The biggest one is damages. You know, we are a system of government where, you know, we don't have a law that if you hurt somebody, you know, you get to put them in jail for a civil, you know, a civil violation that, you know, we don't, if somebody hurt you, like someone punched you, we don't have a rule that says you get to punch them back. You know, the only way we have for addressing ways that people have been hurt is money damages. And so the primary thing that can be recovered in these kinds of lawsuits are money damages. Those money damages are really two types of damages, something that's called compensatory damages, which is to compensate you for harm, and punitive damages, which is to punish somebody for conduct that they should have known was wrong. And you can get punitive damages in a situation where somebody's acting maliciously. Importantly, and we're going to talk about this in a second when we talk about kind of public policy behind Section 1983, the individual government actors very rarely end up paying these damages by themselves. It's extremely uncommon. In most places, they're indemnified by the government, which essentially means if you're doing your job as a school official, as a police officer, as a prison guard, whatever, and you're sued under Section 1983, and you know the person gets damages, the government will pay for it. You know, that's true in most contracts. by most police officers all over the United States. It's true in most contracts of correctional workers. They're not paying their own damages. So sometimes we think about, oh, well, you know, again, if the school board, you know, if a school teacher violated my child's constitutional rights and I sued them and I won $700, you'd think, oh, well, the school teacher's now going to have to pay. That never happens. It's always the government that ends up paying because of indemnification. That's important for some of the public policy issues about these lawsuits, which we'll talk about in a second. They're also frequently limited by insurance, or certain state laws are allowed to cap your damages. So some states say, look, if you sue somebody in our government for violating your rights, the most that you can recover under a statute is, you know, X number of dollars, and that's allowable under the law. So there's other kinds of limits that occur in various places depending on what the law is. The other kinds of remedies that you can get are a declaratory judgment, which really just means a judge can declare that something was wrong. And that's important if you're trying to have a statute overturned, if you're trying to just make sure that conduct stops in the future. Just having a judge say that's wrong can help you do that. So even if you're not really worried about damages, you can get that kind of relief. You can also get an injunction. And again, that's what a lot of these suits to stop stay-at-home orders are about. They're seeking injunctive relief, meaning a judge to issue an order, an injunction, saying, I'm not allowing you to enforce that rule anymore. The other thing that's important about Section 1983, and this again goes to some of the public policy issues we're going to talk about, is that if you're the plaintiff and you sue under Section 1983 for a violation of your constitutional rights and you win, the law allows you to recover your attorney's fees and any costs of your lawsuit from the defendant. And we can talk about that more, but obviously this statute it's Section 1988. The other one we're talking about was Section 1983. This was enacted later, and the point of it was the government said, we want to encourage people to try to sue for violations of their rights. So we think they're more likely to do that if, you know, your attorney's paid for. Basically, you can sue for free as long as you win. So the law gives you that right to have your attorney's fees paid for if you prevail. So that's like a half an hour overview of a very complicated area of constitutional law. I wanted to give some examples of these lawsuits so that we sort of all know what we're talking about. And I think the one example that we just talked about are these stay-at-home lawsuits, and I'm happy to talk about those more with the group. The kinds of basic, you know, the most important, the most common kinds of Section 1983 lawsuits that we see in the United States really do have to do with law enforcement. It makes sense because, you know, one of the most obvious ways that people interact with the government and ways that their rights can be violated is by law enforcement. And so that's where a lot of the sort of more popular kinds of suits that you've heard about are all really in this area. One area of Section 1983 litigation, which is an area that I participate in, is wrongful conviction litigation. And that is where people are saying a state actor violated one of my rights that I'm entitled to, typically around the criminal justice process. And because they violated those rights, you know, I was convicted, I had damages, meaning I was convicted of something I didn't do and I spent a long time in prison. And so I'm suing to recover because of the harms that caused me. So if somebody beats you, you know, tortures you into confessing to a crime you didn't commit, as a result of that, you're convicted of a crime you didn't commit, you have to serve time. They violated your Fifth Amendment right. You know, that's the right against evidence being used against you in court, or you being forced to be a witness against yourself. So you can sue under 1983 for a violation of your Fifth Amendment rights. The Sixth Amendment that we talked about a minute ago requires the government to, or sorry, the Fifth Amendment that we talked about also has a due process clause, and that requires the government to give you any exculpatory evidence. You know, so if the government knows that there's evidence out there that would help you in your criminal trial and they don't turn it over to you, they violated your Fifth Amendment right. So again, the government withholds evidence that's helpful to you that they know about. As a result of that, you're convicted. You are able to sue them for violating your Fifth Amendment right under Section 1983. We also probably all know about police brutality, and I think this is another way where you see these suits in the public, you understand what those suits are about. These are primarily excessive force kinds of cases, or an argument, again, to go back under the Fourth Amendment, that there was an unreasonable search and seizure, that as a result of that you were harmed. I mean, you were injured by the violence against you. And so you can sue under 1983. And this is, you know, police shooting cases, cases where people are killed or hurt by the police. Those are all under Section 1983. There's also cases where people allege that they were abused, you know, sexually abused by a police officer. Those also fall into this category. Then there's prisoner civil rights litigation. To go back, you know, we said we have this 8th Amendment that prevents cruel and unusual punishment. And so people in prison that say, hey, I'm being treated cruelly and unusually, they can bring suit under Section 1983. And that can include things like I wasn't given medical care, or that something about how I'm being treated in prison is violating my 8th Amendment by, you know, causing me harm or causing me suffering. I thought it would be interesting for a second, and maybe this is some of the questions in conversation that are useful for people to have, to talk about the pros and cons of Section 1983 litigation, because I think there's people in this country who feel very strongly that, you know, we have a constitution, that because we have these rights, people should be able to vindicate those rights. Section 1983 is the mechanism for doing that, and so it's great that we have it. And then there's people that say, you know, why are we suing these police officers? It's hard to be a police officer. They're doing their best. And I don't like it that there's a, you know, a section of the Constitution that gives people the authority to sue people this way. Why do we let this happen? So you can think about it from a policy perspective of what's good and bad about Section 1983. The pros as I see them, and people may think about this in other ways, but the pros that I'm thinking about are as follows. I mean, the first thing is, to go back to the Constitution and what we just talked about at the beginning of this, it is very hard under United States law to incentivize people to follow the law if there's no, you know, consequence if they don't. And so we have this Bill of Rights, and we as people, you know, the way the founding fathers set up our government, you know, wanted people to be able to assert those rights and enforce those rights. And how do we really do that? In our system of government, I mean, you have some choices. I mean, one is a political choice. You know, if you don't like what somebody's doing, you can vote them out of office. Or if you think, hey, you know, the school board in my community is really making decisions that I think violate my freedom of religion, you know, one option is to just make yourself heard at the ballot box. But that's a slow way of getting relief. And it also requires other people to agree with you. You know, that's a democracy solution. But what if you really are the little guy? You know, what if you're the only person who, you know, knows that your rights are being violated and there's not a political solution for you? Section 1983 means even if you're the true little guy, you know, even if you're the one person who wants to enforce your rights, you have the ability to do it yourself, even if nobody else will help you. And it incentivizes people to follow the law. You know, people do not like getting sued. They do not like having to pay damages. They do not like having to pay your attorney's fees if you win. And so if somebody's saying, yeah, you know, maybe we as a city want to have this policy that violates people's rights in some way, but we know if we pass that policy, we could get sued. It could cost us money in court. Maybe that incentivizes me to be more thoughtful about the law and to make sure that I'm following the Constitution. The other thing about Section 1983, like we just went back and talked about, is it's really not that easy to bring a suit under Section 1983. The immunities that we talked about really limit these suits to the most egregious type of conduct. And so if you're worried about, well, I just don't like it that it's so easy to sue, as we've talked about, it's really not that easy. There are a lot of limitations. So if we want to have, you know, a route for the most egregious type of misconduct, Section 1983 does that. Those are some of the pros of Section 1983 as I see it. There's a lot of cons. And if you're a person who views the world in this way, then these are things that you might look at and say, yeah, I don't think Section 1983 does what it's supposed to do. One is this bigger concept of tort reform. And I think we hear about tort reform a lot, particularly in the context of medical doctors and insurance, you know, premiums and healthcare costs in this country, that there should be limits on lawsuits that people can bring because lawsuits cost money. You know, maybe you're a person who believes that's just not how people should resolve their differences, by being able to sue for money. That's not a damage that you value. There are people who think there's just too much litigation. You know, some people think, hey, Section 1983 is being used too much, and I think all these lawsuits aren't good for our country. Like we talked about earlier, some people think that Section 1983 is bad because these costs are ultimately borne by us as taxpayers. Like we talked about, these damages or the attorney's fees are going to be paid for by taxpayers because individual actors are going to be indemnified. The local government's going to have to pay for it, and that means taxpayers are going to have to pay for it. Some people think this discourages people from practicing certain professions. You know, that if And this is sort of the same as the healthcare argument. You know, when people say, hey, insurance, you know, malpractice premiums for doctors are too high, that discourages people from being doctors. Well, some people say, hey, why would anybody want to be a police officer or a prison guard if they can be sued and have to deal with these lawsuits? You know, we don't want to disincentivize people from doing these important jobs. Some people say, well, if the point is to deter people from misconduct, you have this situation where the bad actors don't even necessarily pay the damages themselves. So what's the point of that? You know, why, you know, this doesn't even deter anybody. So sort of what's the point? Some people think, well, people could pursue these claims other ways. You know, you could sue somebody under state law. Why do you need to make a federal issue out of something that you could sue for in state court and sort of give states the rights to better manage what their own state actors are doing? Some people say too, well, if your goal here is to reform the criminal justice system, to reform what police do, to reform what prisons do, to make those things better, there's better ways to do it than letting people sue. You know, we ought to be looking at that in terms of legal changes, political solutions like we were just talking about. You know, lawsuits are not the way to get that done. And some people, to go back to what we were just talking about, say, you know, I'm an originalist. Some of you may know that there's sort of this big debate in the law about how we interpret the Constitution. And it kind of breaks down into two camps. One are people called originalists who essentially say, you know, my view of the law is that we ought to think about what the founding fathers, what the framers of the Constitution intended. You know, what was in Thomas Jefferson's mind when the Constitution was being drafted, because that's all I care about. And I want to think about what the original founding fathers meant. And I think it's pretty clear that the founding fathers, you know, probably weren't necessarily thinking about bringing these kind of suits. Is that something they ever envisioned? It doesn't seem like it, given that it took so long for these suits to become something that occurred. Some people are what's called legal realists, and they believe, hey, the Constitution is a living document. It changes over time, and I'm fine with that. And my goal is to do justice and help people have their rights in sort of whatever time they're living. And I'm not as concerned about what the founding fathers were thinking. But some people look at originalism as a reason to say, yeah, you know, I think the way that people bring these suits doesn't fit with what the, you know, original people that wrote the Constitution or wrote the Bill of Rights intended. So there are arguments on both sides. Obviously, I'm a person who, in my career, represents people who I believe's constitutional rights were violated. And I believe that having the ability, again, as the little guy, to bring a suit to protect your own rights against the tyranny of the majority is a good thing. There's people who feel differently about that. But this is an important mechanism that we have now to enforce the Constitution. It's one of the main ways that's being done in a variety of ways in the law to protect a variety of these rights under the Bill of Rights. So I'm happy to answer any questions people have, or if people have, you know, comments they want to make about this, or thinking about the, you know, policy behind what we do in this area of the law. I'm happy to talk about whatever people want to talk about.
Barrett, thank you very much for a very enlightening presentation. And I do have a question. Well, first of all, anybody that has questions, please use the raise hand on the participants and we'll call you as they come up. But I do have a question. And this gets back to the lawsuit about having to wear masks and the restrictions during this current situation. The Declaration of Independence gives us the right to life, liberty, and the pursuit of happiness. Now, they're suing on that basis. I also have the right to my life, my liberty, and my pursuit of happiness. And if authorities, medical authorities, are saying that wearing a mask will help prevent getting this disease, doesn't my right supersede somebody's individual right to their, you know, wanting the government to stop saying use masks and stay at home? And don't I have the right to protect my life in any way, fashion, form if I feel that my life is threatened by someone who is going to spread a deadly disease in this case?
Well, I think that's, you know, I think that's the $1 million question. And I bet, you know, we got 58 people on this chat. I bet we're going to find that we've got 58 perspectives about this issue. And I think it's a hard one. And one of the reasons it's hard, to go back to even what we just talked about, is that when you read the Bill of Rights, the framers were, you know, when they wrote the Constitution, they said, you know, we have these inalienable rights, the rights you just talked about, life, liberty, and the pursuit of happiness. And they never explained what they meant by that. You know, they said, you know, these are principles we believe in, but we're not going to define them for you. And even in the Bill of Rights, you know, when you look at it, these things are not really defined. I mean, why do we have arguments about what the Second Amendment and the right to bear arms means? It's because the framers did not really explain this to us. They did not, you know, they did not explain out what they meant. And so it's a debate. And what the people with these stay-at-home orders are arguing, what the people that have brought the 1983 lawsuits about these orders have argued is, you know, the most important freedom, the freedom that should trump all else, is liberty. You know, the freedom to do what you want. Obviously, government is always, in my view, you know, pushing back against the freedom to do whatever you want, because it's what you just talked about. It's, yeah, the freedom to do whatever you want if it's not, you know, impinging on somebody else's rights. I actually just saw a quote from Abraham Lincoln while I was putting this presentation together, where he said, you know, your rights end where my nose begins. Essentially, you know, you have the freedom to do whatever you want as long as it's not hurting me. But that's obviously the debate we're in now, because there's many views about who's most hurt, whose rights trump other people's rights. And in a situation where, you know, there's so much uncertainty and people don't even agree on the basic facts about what's happening, I think it's very hard to figure out what to do. I will say that of the stay-at-home orders that have been litigated under Section 1983 so far, you know, there's been some in state court, but for the ones that have been in federal court, the federal courts have not been real interested in vindicating people's rights not to wear masks and vindicating people's rights not to stay home. But, you know, there's many different political views about this. So I think it depends a lot about, you know, where you live and what your view of the facts is. I mean, these are divisive issues, I think.
Thank you. Larry Holtzman.
Yeah, does 483 cover a suppression of voting rights? Because there is a law, the government passed the Voting Rights Act of, I think it was during the civil, in the Lyndon Johnson area. And now we're seeing a lot of suppression of voting rights. Does 480, can a group sue to restore their voting rights on the 483?
They can. If you go back to the language of Section 1983, we've talked a lot about this being a constitutional, a way to challenge constitutional rights, but it also actually says a deprivation of any rights that are secured by the Constitution and by laws. So the Voting Rights Act obviously comes out of the civil rights amendments to the Constitution that we were just talking about, including an amendment that gives you the right to vote. And so actually, there's a constitutional right to vote in addition to the Voting Rights Act. And Section 1983 would be the way that you would bring a claim to challenge that. Again, the question would be, what kind of remedy are you seeking? Are you seeking an injunction, meaning you're seeking to have a judge order that, sorry. Are you seeking to have a judge order that whatever voting provision is violating your rights shouldn't occur? Are you seeking damages? What are you seeking? But Section 1983 allows you to challenge that. I think there will be issues that will come up about this, probably especially about the absentee ballot issues that are going to come up with voting this year, where people will bring these challenges.
Thank you.
Ed Roloff.
Thank you, Kara. This is a wonderful presentation. My question is, if you're an originalist, how do you reconcile things that did not exist? You mentioned earlier the 911 call center.
Well, I mean, if you want to read about constitutional interpretation and how you stay an originalist, even though the world has changed, you'll find many, many different people who, you know, have a lot of different views on this. And there are people, you know, there's the Supreme Court has some noted originalists on it now. I mean, Justice Thomas Justice Scalia before he died, Justice Alito. These are the important originalists on the Supreme Court now. And what they would say as to the 911 centers is they're looking for analogies. So they are saying you want to analogize as much as possible to whatever the world looked like at the time of the framers. And you're just trying to go back and say, in the framers' mind, what would they say about a 911 call center? Would they say that those people were entitled to immunity? And if you look at any of the cases that look at immunity, that's what they're doing. They're going back and literally saying, at the time of the framers, you know, what immunities existed. And they always go back to common law. As probably many people on this, in this meeting know, you know, our system of law comes from the British common law. And under common law, there were certain rules that had developed about who could bring suit, and all that gets brought over to the United States. So when you see lawsuits, or when you see case decisions that are trying to look at, let's go back and look, they're literally going and reading British, you know, rules from the 1500s and saying, can we find an analogy? So I think that's how originalists would try to do that. I mean, I would just say that for people for whom originalism is hard, they would say, well, how can we look at what the founders intended when at the time, you know, that the Constitution was passed, slavery was legal in this country, women, you know, were considered property. The framers didn't even envision that everybody in this country would be able to vote. They envisioned that voting would belong to people who own land. You know, that's not suffrage, that's not universal suffrage. That's essentially wealthy people get to vote and nobody else does. And so how can you look back at a system that was unequal at the time of its passage? Now, to be fair to originalists, and I'm not the best person to defend their view because I'm not an originalist, but originalists would say, we analogize, we go back, like, yes, we acknowledge some things have changed, but we're trying to look at the world from their perspective. And I think that's what they try to do.
Thank you very much.
Shelley. Sheldon.
Yes.
Go ahead. You got your hand raised.
Yes. I've heard over the years that ignorance of the law is no excuse. And I heard some things this morning that indicated that if a person wasn't fully aware of some obscure items and so forth, that they took a different view of it. Could you explain that in more detail?
Sure. We were talking about this concept of what's called qualified immunity. And qualified immunity says that if you didn't, it says essentially that if you didn't know, you know, that what you were doing was a violation of the Constitution, you can't be sued. Primarily that means what the standard really is, though, is the reasonable man. You know, this is the objective standard, the reasonable man standard. So to go to your point, ignorance of the law is no excuse. Well, ignorance of the law is no excuse if you're a reasonable person. So if you're a reasonable person that's just a government employee trying to do your job and you reasonably educate yourself and you know the law that's out there and you just really didn't know that what you were doing violated those rules, then you have immunity from suit. You're going to be okay. If you're an unreasonable person, and this gets discussed in constitutional law a lot, actually, is like the ostrich analogy. You know, if you put your head in the sand for fear of what you might see, you're not a reasonable person. If you don't bother to even read, you know, available rules or regulations, you're not a reasonable person. So ignorance is no excuse, but reasonable ignorance is an excuse. So you can amend that, and that's, I think, what the law would say.
Thank you.
Okay, Joe Raccanello.
Yes, very good presentation. I noticed in your presentation you mentioned police brutality, and that's always kind of a tough area. And of course, today, as you know, they're using cameras to kind of prove some of that, and some other areas and technology they're introducing just so that a police officer can protect themselves. I'm wondering from a legal standpoint, you as a lawyer, when you're defending a police officer, what do you kind of look for? Are these some of the things you routinely ask them? Some of the new technologies that are out there today, and just ways of law enforcement people protecting themselves, and more currently with technology being more of a factor?
Yeah, I mean, it's a great point. And I think one of the major, some people that are really opposed to expansions in Section 1983 litigation, their concern is you know, these cases aren't always about the truth. They're just about, you know, the fact of getting sued is tough. And a lot of municipalities might say, yeah, we got sued or our officer got sued and we don't think that's fair. But we're going to just settle with somebody because the risks to us are so great. And so they're worried in those situations that, hey, we won't ever really get a chance to show what happened. And obviously technology is a way to help, you know, be a better fact finder, show what happened. I mean, I read, and people on this call may know about this. I don't know anything personal about this case, but the poor jewelry store owner that got killed in Stamford a little bit ago, you know, they caught those guys because of the prevalence of cameras in Stamford. You know, there was a camera that obviously showed the Dairy Queen parking lot, which is where those guys were kind of getting ready to go do that jewelry store robbery. And the guys are caught on camera changing into their masks to go, you know, rob that poor man and kill him. And that's the reason they were caught, is because of the proliferation of security footage in the United States. And so, yeah, I think cameras, footage, objective evidence of whatever kind is helpful. It's helpful to prove what happened in court. The opposite is true too, though. And I mean, one of the biggest examples of this, and I don't know how many people on this call know about the Laquan McDonald case in Chicago. I do some work in Chicago, and that was a big deal out there, where this 15-year-old boy was killed by the police. This didn't end up being a Section 1983 lawsuit issue, really, but one of the police officers that shot him was charged with his murder. And there was camera footage of what had happened. There was body camera footage, and then there was camera footage from a Burger King across the street. That footage showed the officer killing this boy with him not doing anything. I mean, he wasn't coming forward. He was just standing there, and he was shot and killed. And what the officer actually argued was, wait, this camera footage doesn't really show the truth because it's misleading. And so he called experts in that trial to try to show why the camera footage didn't really explain the story. And I know that there are some, like Fraternal Order of Police and some other police unions that are worried that camera footage will be misleading and won't necessarily show the truth. It doesn't necessarily show things from the officer's perspective. It doesn't necessarily take into account that sometimes police officers have to make decisions extremely quickly. You know, you can rewind a camera footage and watch it 100 times and watch it in slow motion and pause and think and replay. And that's not how people make decisions. They make decisions on a split second. And so, yeah, I think camera footage, ways for us to know what happened, can make these suits easier, but does that sort of solve the issue? I don't know if it solves it entirely. I don't know if police officers would say that it solves it entirely.
Okay, guys, any more questions? Okay, seeing none. Tara, thank you again for your presentation. Very informative, very educational, and in light of today's situations, I think we can see things from different perspective now, or from the proper perspective. Again, on behalf of our membership, thank you for taking the time to spend an hour with us today.
It was fun to join you all. Thanks for having me.
Great. Okay, with that, I think we'll adjourn the meeting and hope to see everyone next week. Stay well, stay safe, and have a life. Don't fall, get depressed.
Thank you. Bye-bye, everybody.
Thanks, Joe. Thanks, everybody.